Yo, what's up everyone? Ronny Caruso here, psych major, forensic linguistics minor, host of Hard Flip. Today, coming to you live from London because my dad, Lieutenant Caruso, was asked by the superintendent for help on some particularly infamous case. So I figured I'd run the show from good old England. Quick brag, I'm a professional skateboarder, won the X Games twice in a row and participated in the 2024 Olympics as a pro skater. I also run the Ronny Hard Flip Band and the Hard Flip Talk Show. Yeah, I keep busy. And of course, I'm fully in the Apple universe. iMac, MacBook Pro, late 2024, iPad Pro, iPhone 15 Pro Max. And yes, I'm still hoping Dad, Lieutenant Caruso, will finally get me that Apple Watch. Marina, my duck, is keeping me sane. She's a great listener. All right, enough about me. Let's set the stage for today. We're diving into the Nicholas Browning case, originally from 2008. He was 14 back then, which actually is the year I was born. Now he's 31 years old, and as rumor has it, he might be eligible for a parole in about 10 years at the latest. Given good conduct, this is the guy who killed his parents and his two little brothers. 4 lives lost. Crazy, right? We've got a full panel, experts from the US, Germany, Spain, the UK, and even a former inmate to break it all down and tell it like it is. And first question, considering Nicholas Browning's age at the time, how should the law balance accountability with developmental immaturity?
Episode 30 Hard Flip with Ronny Caruso, Criminal Justice Reform Special. Scene 1 Kickoff.
We're not in theory. We're in Maryland. And we're talking about a case where 4 people were killed. Under Maryland law, that's exactly when the system allows a juvenile to be waived into adult court by judicial decision. And it happened here because the offense wasn't minor. It was extreme. This is about the case of Nicholas Browning. And once that waiver happens, the case moves forward as an adult criminal matter. That's the law working as designed.
Pero eso es exactamente el problema. Usted está tratando a un menor como si ya fuera un adulto completo. En España, bajo la Ley Orgánica 5/2000, el enfoque es distinto. La ley no solo castiga, también reconstruye. No se trata de ignorar el crimen, se trata de no perder al joven para siempre.
Whoa, hold up. We've got 2 systems doing kickflips in opposite directions. Maryland's like, you go big, you land big, you deal with it. Spain's like, you fall, we still teach you how to stand up. And honestly, that's a whole philosophical grind right there. As Kierkegaard would say, you don't just become a self, you choose it.
And that's exactly why this case matters. Because when a juvenile commits an act like this, the law doesn't pretend it didn't happen. The waiver exists so the court can treat the case at the level of the harm done. That's not about emotion. That's about structure.
Pero esa estructura puede destruir la posibilidad de cambio. Un sistema que no contempla la reinserción corre el riesgo de convertirse en solo castigo.
We will ask the professor to translate for our Anglophone audience.
What he's saying is simple. The Spanish system is arguing that even in extreme cases, the goal isn't just punishment, it's reintegration. They're not denying the crime, they're questioning whether the system should define someone forever by it. So now my own voice. I'm Dr. Stephen Martz. I work in linguistics, including forensic linguistics, but my main focus is on systemic-funcional linguistics, and I've advised law enforcement in criminal cases. With regard to this, I'm more aligned with Mr. Sanchez's, the Spanish attorney's position. I'm in favor of rehabilitation as a core part of how we respond to cases like this. Because in a case like Nicholas Browning, the system is making a choice about whether this person is treated as something fixed or something that still has the capacity to change. And if you remove that possibility entirely, you're not strengthening the system, you're narrowing it. And systems that only know how to punish don't actually resolve the underlying problem. They just stabilize it.
All right, now we're cooking. So here's the real question for you watching, especially the UK crowd. Don't get left behind. Are you the kind of system that says, you did this, you answer for this, end of story, or the kind that says, you did this, but we're still going to try to bring you back? Drop it in the comments before the professor starts cooking. And don't be British slackers. You know you're watching anyway. Okay, let's bring in the next panel.
Scene 2. The uncle.
Enough! You sit there in your ivory tower playing with linguistics while I sit here with the blood of 4 human beings on my hands. You want to talk about the law? Let's read it. Maryland Code, Courts and Judicial Proceedings, Section 3-8A-06, clearly states that the court may waive its jurisdiction over a child if the child is at least 15 years old and is charged with an act that would be a felony if committed by an adult. It allows, I consider the nature of the offense and the public's safety. Nicholas Browning didn't just commit a crime. He executed his parents and 2 children, his own brothers, while they slept. To suggest he is rehabilitated because he's reached the age of 34 is a dereliction of my duty to the citizens of this state. If the streets were filled with people who followed your linguistic interpretation, we wouldn't have a society. We'd have a slaughterhouse. This isn't a text to be deconstructed, Doctor. It's a quadruple murder. There is no second chance for the boys in the ground. And as long as I hold this gavel, there is no parole for a man who chose to erase his entire bloodline before he could even drive a car.
Let's be intellectually honest for a moment, Judge. First, Maryland Code, Criminal Procedure, Section 8-110, enacted via Senate Bill 494, 2021, does exist. Furthermore, you speak of a law as if it were a static monolith, but the law is language, and language is a living system of interpretation. You are a reader of texts, nothing more. To reduce my position to cloud cuckoo land because I apply systemic functional theory is to admit you don't understand the very tool you use to incarcerate, the word. You treat section 3-8A-06 like a divine decree, but it is a string of signifiers written by men who didn't understand the adolescent brain. In most European jurisdictions, a 15-year-old, a one-time offender in a closed, abusive family system, would have served 5 to 8 years and been rehabilitated. Why? Because they recognize that a quadruple homicide within a specific, alleged, that is, unverified, toxic domestic pathology does not equal a serial predator. Nicholas was 34 this February. He has been buried in your system for nearly 20 years. He was 15 when he committed the felony. At what point does justice stop being a corrective and start being an archaic, symbolic ritual of bloodletting? We have separation of powers for a reason, yet here we are, watching case law allow a judge to effectively write new statutes from the bench, blurring the lines between Article 1 and Article 3. That isn't checks and balances. That's a judicial ego masquerading as a constitution. Here in Europe, taking all Western European countries into account, all the jurisdictions, he would serve an average of 7.2 years. Granted, this is an approximate, you may even call it fictional number, that we calculated on the basis of specific parameters. Linguists do not judge, they observe. We do not say better or worse. To me, The two judicial systems speak to different languages. That's it. I understand one better than the other, but this may not meet universal consent, which I am not seeking. I am comparing.
Judge, please. You're talking about my family like they are just evidence files. I was there. I saw the bruises on Nicholas that the neighbors ignored. My brother, Nicholas's father, was an abusive man who ran that house like a prison camp. Yes, what Nicholas did was a horror I wake up to every single night. But he was 15. He's been in a cage for 19 years. 19! He has spent more of his life behind bars than he ever spent as a free child. The professor is right. It stayed in the family. He isn't a threat to the man on the street. He was a boy who snapped under a weight no child should carry. You call it aggravating factors, but what about the mitigation of a broken home? What about the fact that he's educated himself, counseled others, and become a man who weeps for what he did? Is there no room in your Section 3-8A-06 for mercy? Or is that word also just fluff to you?
Whoa, the professor is coming for the judge's credentials, calling the law just letters on a page, and the judge is throwing the book back with the weight of 4 coffins. This isn't a debate anymore. It's a war over the soul of the 2026 reforms. One side says the brain is a work in progress. The other says the crime is a permanent stain. Professor Dr. Martz, they're ripping into your theory. They're saying you're soft on crime and blind to the victims. Give it to them straight. Use that linguistic authority. Explain to the crew why a quadruple homicide in 2008 doesn't mean a danger to society in 2026. Hit them with the truth before they pull the plug. We now go into a short commercial break, and then I will interview the professor alone. Thanks. Stick.
Scene 3. Coffee Fellows. The setting is late. The neon sign of the Coffee Fellows flickers against the rain-slicked window. A half-empty Coke Zero sits on the table between them. All other patrons have left. Only the hum of the refrigerator remains.
Professor, I've been digging through the archives. People on YouTube are already circling this. They think it's a slam dunk for the judge because of the finality of 2008. But I found the 2021 Juvenile Restoration Act. The facts are these. Nicholas isn't eligible yet. He's at 18 years. The law says 20 years before he can even ask for a second look. That puts the real confrontation in 2028, when he can finally ask for a second look. If we talk about this now, are we creating false expectations? Or worse, misleading the audience? Is it even appropriate to broadcast a debate on an active life sentence case like this?
Ronny, the label of misinformation is often used when people feel challenged by the text. We aren't spreading disinformation. We are providing linguistic and legal context. Discussing the Nicholas Browning case is acceptable. It's part of the public record. High-profile legal analysts like Joshua Ritter do it constantly. We aren't intruding on a private citizen. We are critiquing a public judicial act.
But the numbers, Professor. If I tell the audience he's coming home, and then the judge shuts it down in 2028 because of those 4 consecutive sentences,
Then you explain the systemic failure. The fact is, Nicholas may have the right to petition in 2028. That is the framework set by the statute. Our job isn't to predict the future, it's to highlight the discrepancy. We tell the public, as of 2026, the law treats him as a permanent prisoner. In 2028, the law must decide if he is a man. We use a general Western European comparison on the order of a single-digit number of years. We stay by the book, Ronny. We quote Maryland Code, Section 3-8A-06, and then we deconstruct it. That's not speculation, that's scholarship. By the way, Ronny, your producers had you booked on VS-142, a Boeing 787-9 from Los Angeles to London Heathrow.
so after you agreed to appear on the talk show special in London, what happened?
After that appearance, I spoke with your producers directly. They arranged to rebook you on my behalf.
So you called them and they just agreed? How did they do that? And why? I'm curious. You want me to stay in London and hang out?
They negotiated it with the airline. The producers agreed to cover the rebooking on one condition, that I would appear for free on your show.
So the producers pay for the rebooking, so I got to keep my guest and they won't have to pay an internationally known full professor? That's actually clever.
In return, I asked them to book you on my flight back to Barcelona at Lengua Explorer LXE 7831, departing tomorrow at 9:10.
Airbus 321neo, according to FlightAware. And I'll stay the entire week, Easter break. That wasn't an accident, was it?
Right, Ronny. And then you return on LXE 5468, an Airbus 350-1000. That's an upgrade.
Kierke once said, "You live forward but understand backward." And this is one of those moments. I'm not rushing to understand it. I just want the time. You didn't just move a flight, you made space for something real. And going to Gaudi City with you? I respect that.
Good.
Let's see how your plan holds up once we land, because if this is how you arrange things, I'll follow your lead. The end.